and welcome to another installment of our trial tutorial series. This program is on persuasive storytelling. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and I'm absolutely delighted to welcome back our speakers for this program, Elizabeth Hernandez and Scott Glovsky. Scott is an award-winning trial attorney and founder of the law offices of Scott Glovsky. His practice focuses on taking on health insurance companies in the face of coverage denials. Scott has represented individuals and large classes of plaintiffs in his pursuit for justice. Among other honors, which are too numerous to name here, Scott is the recipient of the California Lawyers Magazine California Attorney of the Year Award and the Consumer Attorneys of California Street Fighter of the Year Award. He is also a faculty member at Trial Lawyers College, where he teaches lawyers from around the country how to successfully try cases. Elizabeth is an attorney with BD&J PC. She handles their most complex and life-altering cases. For years, Elizabeth has served clients across Southern California as they navigate the complicated world of catastrophic personal injuries and wrongful death. Elizabeth's outstanding outcomes for her clients have earned her numerous industry accolades, including recognition by her peers as Best Lawyer in America in the personal injury litigation practice area, a place on the Daily Journal's Top Women Lawyers, and as the 2025 Mexican American Bar Foundation's Professional Achievement Award recipient. Elizabeth holds memberships and leadership positions on numerous professional organizations and is currently the president-elect of CALA. We can't wait to hear what they have to share with us today, so I'm going to turn it over to them.
Good afternoon, everyone, and thank you for being here. We really appreciate it. Scott, I'll let you say hello to everybody.
Hello, everybody. Thanks for joining us. We're happy to be here, and hopefully we can share some ideas, and feel free if you have questions, after the program even, to reach out to us anytime. We're happy to jump on the phone and see how we can help.
And we just want to give you an overview of what we're going to cover. So this is kind of a part 2 of our storytelling. And we are going to get into some specific examples, including on voir dire, jury selection, and also with the opening statements. But what's most important at any part of the trial and any part of the case is really discovering the story. And we're going to be talking about that some more in depth and give some examples. And we would like to share some information, so hopefully this will help you all tell your client's story. So all of us as attorneys, whether we're trial attorneys, litigators, or whatever type of attorney, we represent clients, so we get the privilege of telling our clients' stories. We are all storytellers. So it's important to note that the majority of our clients have never been through anything like this before. I primarily handle catastrophic injury cases. So you're dealing with folks who have life-altering injuries that not only affects themselves, but also their family and their loved ones. A lot of times it may be hard to get information out of them because some of them are living and dealing with pain on a daily basis or significant loss, and it's not something that is easy to talk about. So part of trying to bring out the client's story, whether it's at mediation or working up the case, and especially at trial, is really trying to build that connection with the client and even others, family members, friends, co-workers, colleagues, what have you, to try and put that story together to make it as most effective as possible. Scott, I don't know if you want to share anything.
Yeah, no, I just want to reiterate. Trial lawyering is about connections with our clients, connections with the jury, connections with judges. And the way we connect with people is through our emotions, through our feelings, and through stories. So a lot of what you're going to hear us talk about today is discovering the story for your trial. What's going to resonate with the jury? And I'm distinguishing the facts from the story, because stories are what drive verdicts. Stories with emotional connections, not facts.
So what we first want to talk about is how we would look at the fact pattern that's been presented. I believe most of you, if not all of you, received the fact pattern with some materials. I will share some portion of the materials that were provided. We didn't provide slides just because it was about spending a lot of time in providing some detailed information in the materials to share with everybody. But if you're not familiar with the fact pattern, this involved a married couple who went on a vacation on a cruise. And during the cruise, the husband decided voluntarily to get involved in one of the contests that were being held by the cruise ship for a belly flop contest. And during that contest, he dove in headfirst into one of the pools that was on the cruise ship. It happened to be 4 feet deep throughout the pool, and he dove in headfirst, hit his head, and sustained some serious injuries, including head injuries, neck injuries, cervical spine, and back. So that's a gist. And his wife was there and present at the time. I don't know if you want to add anything about the facts, Scott.
No, that's good.
Okay. So, in first looking at the facts and going through, there's a lot of information there that whether you're on the plaintiff side or the defense side, because it is a civil litigation case that we're dealing with. So, it's not a criminal case. And so, it's basically piecing things together to start putting together the story. And something that we both like to do separately on our cases is consider the themes, look at obviously the liability and what facts there are that we know of so far. And it's basically getting more facts to add to the story or bringing out the facts to help us tell the story, but also looking at what should we be concerned with, what we often refer to as danger points. So we wanted to cover that first and go through how we would look at this fact pattern and pulling out that information. This is all a process of putting together the story. And then in terms of just taking the voir dire, how we would approach in the voir dire, what issues we would want to bring up specifically to prospective members of the jury to find out what their beliefs are, if there's any biases, and give it specific examples of questions. Also, in terms of framing certain issues and reframing. So, with that in mind, what I'll go ahead and do is I'm just going to share some of the materials that were sent. We're not going to go through all of the materials, but just a portion. So, in the beginning here, there's some potential liability themes. We put it up the front. It doesn't mean you're going to know your themes in the very beginning. That takes some work in exploring what the facts are, gathering as many facts as possible, seeing what evidence you have. But for this particular case, the fact pattern that was provided to us, some liability themes we would want to know in terms of negligence of the cruise ship and the directors, its employees, assumption of the risk or comparative fault in with respect to our client, Nathan, the husband, and also we want to know about the scene. What was there? Who was there at the pool? What was there? Were there any signs? Anything about no diving, especially head first? So that's some of the issues. And then since we're dealing with a cruise ship line and a company, corporate responsibility is often a big theme in these cases and in terms of catastrophic injury cases. So the cruise line is Vacations by the Sea. Was there any training of their staff on safety issues? Was there anything that the staff did on that day or the higher ups of Vacations by the Sea to prohibit belly flop contests or to make sure that any contestants will be safe? Was there any type of failure to supervise? And so those are some just general themes. Scott, do you want to add anything to that?
No.
Okay. So then in terms of danger points, the goal is we want to identify them And for some of the danger points that pertain to the plaintiff side, we want to reframe those danger points. So some just overall danger points that we may look at when we go through this fact pattern is one, are there any kind of common sense biases? For example, again, this is a big issue. The pool was only 4 feet deep. Isn't that obvious to anybody? Even say without signs, even without some type of warning, isn't it obvious that no one should dive in head first? That's something we would have to, that's a possible significant danger point. Again, the potential or prospective jurors may be thinking, well, didn't Nathan know better? He's an adult. How would he not know you shouldn't be diving in head first? We learned that as a kid, right? Why would you do that as an adult? And there's also another issue in terms of the fact pattern, where it does talk about he went after this incident happened while on the cruise ship. He was escorted to the infirmary where a general practitioner doctor did some type of evaluation. There's question marks as to the extent of the evaluation, but the next day the cruise was over, and he then waited a week before getting any medical treatment. But during that week before he received medical treatment, he had already retained a lawyer. So those are definitely red flags. You can call them red flags, danger points, however you want to phrase it. But those are some things that we have to look at. So just a general overview. If you're the plaintiff representing the plaintiff and these red flags or danger points come up, one thing you want to do to try and reframe is, for example, the pool being 4 feet deep. Now, we know that in some pools, in one side of the pool, it could be the shallow end. So you have the pool's 4 feet deep. But on the other side, it could be that it's much deeper. That wasn't the case in our fact pattern. The fact pattern said the pool that was used was 4 feet deep throughout. Now, you also need to know that on this cruise ship, obviously, there's not just one pool for everybody to use. There were other pools on this cruise ship. So why the organizers decided to use this particular one when it's only 4 feet deep, that's also something to consider. But in terms of rephrasing this particular danger point or red flag, a way to do that is emphasize that the passengers are guests on this ship. They're paid guests. They rely on the cruise staff who's putting on these programs. They rely on them to make sure that they're going to be safe. No one is voluntarily going to do something where they're going to injure themselves significantly. That's the other way. That's one way to kind of rephrase it. And comparative fault themes. This is what also needs to be explored in discovering the story. Was Nathan impulsive? Was he just being impulsive? Did he think this through? Had he been drinking alcohol? Was he impaired in any way? Or even if he wasn't drinking alcohol, what about medication? Was he taking any medication that made him groggy? On cruise ships, people are on vacation primarily. They're having a good time. Some people are out partying until late. Was Nathan sleep deprived where he wasn't completely focused? Also, in terms of his build, was he physically fit to even be doing this type of contest? So those are some things to look at. But there's a list here that's provided in the materials of comprehensive danger points or red flags. And there's going to be plaintiff can put together their red flags or danger points, and defense can put together theirs. But some you can see, one we talked about is the pool depth, 4 feet. Second, he dove in head first. 3, we'd want to know there was no lifeguard present. What about medical staff? We know a lot of times when there's some type of contest or competition or even race, you sign up for a 5K run, there's usually some type of medical staff present. The facts didn't indicate whether there was a medical staff present. So these are all danger points. You want to gather this information, and this is going to help when you speak with your client. And it's, again, the danger points that you gather, whether you're on the defense side or the plaintiff side, you want to gather all of these, and these are things that you want to talk about in discovering the story with your client. Questions about whether a waiver was signed, that comes up. So you can see there's a number of them that I put here. Also, there was an issue with when Nathan went to the doctor a week after he disembarked from the ship, that it was doctors that his attorneys sent him to. So that's definitely a red flag or a danger point that needs to be addressed by the plaintiff side. So in looking at, again, the pull depth of 4 feet, as we mentioned, the defense is going to frame it as an obvious risk. It's shallow water. The plaintiff will reframe it that contestants rely on the staff to ensure safety. Okay, that's one thing. Lifeguard, no lifeguard or medical staff present. The defense may frame that as it wasn't a dangerous event, so there was no need to have them there. Whereas the plaintiff may reframe that issue. The crew staff hosted a physical contest. Medical standby should have been required. Again, you're putting that responsibility on the cruise ship. I want to pause there to see if, Scott, if you have anything that you wanted to add regarding the danger points or the red flags.
Sure. Yeah. Let me step back for a little moment just to talk about this concept of danger points in jury selection. Our goal in jury selection is twofold. One is to find out as much as we can about the jurors and how they're going to feel about the issues in our case. And two is the connection between ourselves as the lawyer and the jurors, so we can have credibility and build credibility and essentially develop the credibility so that we can be building a tribe with the jury where we're the leader of the tribe. And so when we talk about danger points, to me, what that involves is looking at the issues in the case that bother us. Like here, for example, as Liz was talking about, one of the first things is that there are signs that say no diving and signs that say that's 4 feet deep. So by being open and honest about our feelings about the danger points with the jury and voir dire, we can open up a dialogue where we're not trying to convince them or persuade them. We're being open and honest about an issue that we want to know about, that we're concerned about, which invites the jurors to open up and be honest and say how they feel about it. So, for example, I might say in a case like this, like, look, when, what you'll learn later on when the evidence is shown is you'll learn that there was signs that said no diving and signs that said 4 feet is the depth of the pool. And when I look at that, a part of me thinks that, well, if there's signs that say no diving and it's only 4 feet deep, like why did Nathan jump into the pool? And is that, how do you feel about that? And sort of open it up to the jurors so that we can start a dialogue with the jurors. We're having a real conversation about a real issue in the case so that we can find out if some people are going to be like, yeah, I think, I believe in personal responsibility and no one should ever jump in a pool with signs like that. Of course, remember, this is jury selection. And when it comes to opening statement is when we would sort of, present the facts in a way that's going to win the case for us. But in jury selection, we're trying to foster this open communication to where the jurors feel safe to share how they feel about things so we can see who they are. And the more we can see who they are, the more we can see if they're jurors that we want on the case. Liz?
Yes, and those are all great points. And in terms of jury selection, we want to get the jury to talk. And so it's open-ended questions, really. But we give some specific examples just to kind of get to the point here. So, for example, the voir dire or jury selection themes that we may want to approach with the jury and question them about is trust. How do they feel about, their trust in authority, their belief in the crew staff's responsibility, expectations of safety and organized activities, finding out if some folks have participated in organized activities, marathons, half marathons, those types of things. Another theme that we want to question the jury about would be personal responsibility versus institutional duty. Attitudes towards personal risk taking is something. When you go on vacation and you know that you're on a cruise ship and you have people who are paid and hopefully trained to put on organized events, that you want to know that you're going to be safe in doing it. So why not go and enjoy? Does it mean you're taking the risk that you may have a cervical spine injury as a result? No. Also, a big issue is we want to know about, from prospective jurors, their views on corporate accountability. And then in terms of the medical issue with him getting sent to doctors by his attorneys, him retaining an attorney before even getting medical treatment, and there's also some facts that show that even though he did have to take some time off, he was able to return to work. And when he returned to work in the same position, making the same money. So you're really limited in terms of loss of future earnings. We don't know if there's going to be any. And so is this primarily a non-economic damages or a general damages case in addition to the medical care and treatment? So we want to know about any medical biases, skepticism that potential jurors have toward injury claims, opinions. We definitely want to know opinions on attorney referred care. So here's kind of, a little bit of a checklist that we provided, facts to elicit to get some information out of jurors. And then in terms of specific questions, I just will scroll down to that. So for example, trust in authority and safety expectations. What is our goal with that, with respect to jury selection? We want to identify jurors who expect safety from cruise staff and organized activities. So some questions to start things off in terms of picking a jury is, have you ever participated in a cruise or resort activity where you assumed organizers had ensured it was safe? Do you believe people should be able to rely on staff to explain safety rules clearly? How do you feel about companies hosting contests or games in environments like pools or gyms? You open it up at first, and then you want people to talk. And once they do talk, give their input opinions. You thank them for it. If it's something that they're defense oriented, still thank them. And then find out, does anyone else feel the same way? And then if it's quiet, welcome the silence. Someone will speak up. But then you can also ask Mr. Smith or prospective juror number 1, how do you feel about that? And those open-ended questions will allow you to get people to open up. And then you'll start to see that people are either agreeing or disagreeing. And that helps a lot. In terms of the common sense versus institutional responsibility, another theme. The goal is to reframe he should have known better into they should have protected him. So some questions: do you think people should be protected even when they make impulsive decisions? Do you believe warning should be given even for things that seem obvious? And in terms of the medical treatment or the delays, the goal, again, is to address skepticism about delayed care, attorney-referred doctors, and conservative treatment. In the facts, it says that one of the doctors he treated with had recommended that he have surgery, but Nathan decided for some conservative treatment, such as injections and also physical therapy. So some questions that you may want to address or topics when picking a jury is, have you or someone close to you ever delayed seeking medical care because you weren't sure how serious the injury was? How do you feel about people seeing doctors recommended by their attorney? And then we also have with the personal responsibility and risk taking. And there's more that's put in the materials, but I want to give Scott the opportunity to give some input on this.
Yeah, I just want to add, the idea that, many books have been written about communication, and the key to communication is listening, so that when we're picking a jury, it's more important. My friend Joshua Carton, who's a phenomenal communications expert who Elizabeth knows and has been, teaching lawyers, our colleagues, for many, many years, talks about the urgency, the need to connect with the listener, right? And so we're separate and more important than the content of what we're saying is active listening with the potential jurors, the people that we're talking to. So, many lawyers, myself included, we get nervous. We're standing up in front of a jury thinking about our next question, and it's so easy to ask a question and get an answer and then just want to move on to the next question and think in your head about what am I going to ask next. But I would urge everybody to read about active listening, because if we want to connect with jurors, having experience in tuning into what the jurors are feeling, making strong eye contact, and really listening until you get their response. And then when you get their response, honoring their response so they understand, they can feel that you listen to them and that you hear them. And there's training in psychodrama, which is one form of active listening. But I just want to emphasize that point, that communication is always about the listener. So regardless of our content, it's more important, I believe, for us to make that connection so that we're trusted and credible because we care.
And that's a great point that I can't overemphasize. It's so important. So, as attorneys, when we're talking, whether in the office or we go attend events or at mixers, uh, we're talking about a lot of different things, and it's very common that we are talking over each other, not trying to be rude, but it just happens. Now, when you're picking a jury, you are going to have an outline. You're not going to have questions word for word because you don't know how the prospective jurors are going to answer. So that's where Scott is saying the listening is so important. You know in your mind what key topics you want to be able to cover. So you're already going to have that down. What you want to know is what the jurors, prospective jurors, feel. And in order to know that, you really have to listen to not only how they physically are appearing, if they become rigid or tense up with a question or an answering, their tone, and especially what they're saying. That is so important, to be able to really, really listen and take in what they're saying, not just follow an outline and saying, okay, thanks, next question. No, you want to really be able to take that in. So,
and let me add real quick that, this is a talk about persuasion, right? We are never going to change who a juror is in a million years. Their beliefs, their perspectives on the world. The way we persuade is by, in jury selection, is by letting them talk and listening. Because if we can find out who they are, they're either going to decide our case or not, depending on what we learn from them. And so many lawyers I know strongly believe, I agree, that the way we persuade is by listening to who they are and having them on the jury or not having them on the jury, so that the actual jurors that hear our case are open to hearing the case.
and we want to wrap up just this portion, but let me just share another screenshot. And again, it's in the materials, but there's a chart that's been put together about reframing these danger points or red flags, plaintiff versus defense. So some of the key issues is, for example, attorney referred doctors. How would the defense frame that? He only saw doctors after hiring a lawyer. Isn't that a little suspicious? Well, the plaintiff will want to reframe that and use a different strategy. That Nathan sought help when symptoms worsened. Attorney referrals are common when insurance or access is limited. So if he didn't have access to doctors or didn't know where to go and he wants to get proper care, then it's common for attorneys to help. That's a way to rephrase it. No emergency treatment sought immediately. He waited a week, but in that week, he first hired an attorney. Defense is going to frame that he didn't seek medical help right away. So how serious could his injury be? He wasn't really that injured. And the plaintiff will reframe that and use a strategy that, well, Nathan was confused. He hit his head. He was groggy. He relied on the ship staff, to tell him if he had a serious injury, which they didn't tell him that. They allowed him to stay on the ship overnight and then get off the next day. They didn't call a specialist. They didn't fly him out someplace. They basically said, take some Advil, what have you, something minor, and rest up. Also, the delay was due to a lack of onboard care and unclear symptoms. They didn't do the diagnostic testing. They weren't equipped to do it. So that's a way that you can also reframe it, and that's all in the materials as well. But turning now to more on discovering the story. What we've talked about already is discovering the story, but now we're dealing with your client specifically. You've gathered these danger points and red flags. You're going to be talking to your client, but it's how to really bring out the story from the client. Something to keep in mind is, depending on who the client is, we also need to be mindful of what is the client's age. Is it someone who identifies as a man, someone who identifies as a woman? Also, what is the cultural background of somebody? I know in my family, I'm Mexican American. So if my dad, who is very much proud, the image of being the machismo, if he was injured, he wouldn't show it, because you don't show pain. Showing pain is a sign of weakness, how he especially was brought up. So, and that's common in certain cultures. So you want to be mindful of who your client is to try and start basing that connection and building that trust. Scott, did you want to add?
Yeah, no, that's great.
Okay. So when we want to get information from our client, a lot of times we will have some will call the client up and have the client come to the office. That perhaps works. Everyone is very different, but again, it's building that connection with the client. As I mentioned in the beginning, most of our clients, it's the first time they've been involved in anything like this type of litigation, and they have serious injuries that have changed their lives. So coming into an attorney's office, they may not feel 100% comfortable, but they'll do it because their attorney wants to meet with them. Sometimes it's good to think about figuring out where is the space where the client feels the most comfortable. And sometimes that could be in their home. Sometimes it could be at a relative's home. Whatever that may be, it is helpful in discovering the story to actually take the time to go out to the client's home and to meet with the client, to even meet with family members that the client may be living with. And you'll find out that they will be very comfortable, or a lot more comfortable than in an attorney's office, and be willing to open up. Plus, there are things that we as attorneys are looking for that we know would help to basically help us tell the story and put together a strong case. The clients don't know that. Oftentimes clients may think, oh, these pictures they're not relevant, or the attorney doesn't need to know about all of these things. And if you go to a client's home, you not only see pictures on the wall, you might see memorabilia, you might see some photographs they have in a photo album or on a computer. They may tell you about videos. There's a number of things that you may see, and they're willing to open up and talk to you about. So that's one way to discover the story. The other way is to have the client sit there. And even if it's somebody who is not comfortable, kind of you sitting on the couch and them sitting on a chair, kind of face to face, but not right in front of each other, perhaps it's something that, if they don't feel comfortable facing you, you can have them sit in a chair with their back towards you and start asking them questions, however they're going to feel comfortable. But one thing to do in discovering the story is to take them back to that day. As hard as it is, they're going to have to talk about it during their deposition that you have to prepare them for, and they're going to have to talk about it at trial in front of a bunch of strangers who are going to determine the outcome of their case and their trial. So just meeting with the client at first and sitting down and discovering the story that way, and to get them to go back to that day, as painful as it may be. You have to be very delicate and sensitive, but just have them work with you. I want to take you back to that day. And then we can do a little role playing here too. Scott's going to play the role of Nathan. So, Nathan, I know that how difficult this may be, but to help us really understand what you went through and be able to explain it to a jury when we go to trial, I want to talk about it now. And we can take breaks, but I want you to, in your mind, go back to that day when you're on vacation with your wife. Okay.
Okay.
And tell me when you're ready.
Okay.
All right. And let's go to the point of when you were heading over to the pool before you decided to join the contest. Take us back and tell us how you were feeling that day.
Yeah, I'm sitting on the deck chair, which is got those, like, it has these white rubber strips, and it's white with white strips and blue strips. And I'm on the deck chair. It's a beautiful sunny day. I can feel the sun on my hands and on my legs. I can feel a little bit of the breeze that's coming, a little bit of a cool breeze that's coming and going. And I can look in front of me, and I'm in front of my deck chair. I'm right at the pool, and the pool's right in front of me. When I look in front of me, I see the pool's this beautiful blue water with the pool sort of in a rectangular shape. And right in front of me, the pool starts like about 5 feet in front of me, and it's probably 30 feet long and about 20 feet widthwise. And on my right, I've got all the other deck chairs that are lined up with people lying in the deck chairs. When I look over to the left, I see the railing of the ship, and beyond that, just the beautiful blue ocean. And I can smell the fried food, like the chicken strips. From the guy next to me is eating chicken strips and French fries, and I can hear lots of people talking. And then this guy is standing at the corner of the pool, with his uniform on. He obviously works for the company, and he's telling us about the pool. He's trying to get everybody in to come join the belly flop contest.
So we'll pause there for a second. So the ultimate goal is to want to get as much detail and information as you can from the client. So we know that the clients, you may have some clients who are talkative, and somehow you're trying to really pull the information out of them. So this is a process. You may not get a client like Scott right now who is going to be that detailed at first, but you take it in bits and pieces to try and bring out as much detailed information as possible before you get to, you're setting the scene, setting what your client saw at the time, how he was feeling, what he observed, all of the senses, so that you can bring that to life as to what he was going through and how he was feeling at the time. Do you want to add to that, Scott?
No, I'm feeling great. I mean, my wife's next to me. We're celebrating her birthday. I'm drinking my 7-Up and relaxing. It's so nice to be here on vacation in this beautiful place. And then there's the guy who can I reverse roles with the activities director?
Yes, and for the audience, this is something you can do if you want him to play the role of someone else who was there, or perhaps the defendant. You can have your client do that as well. So Scott's showing you different roles that you can have the client play. One is the client going back to that day, what he observed, how he felt, the senses, and the other is, okay, now I want to be in the role of this director, the cruise ship director. So go ahead, Scott.
Yeah. Come on, everybody. It's time for the belly flop contest. Come on. Come on. This is great. We do this every cruise. And for the winner is going to get a gift certificate for the bar. So come on, don't just sit there. Come on, let's do this. Let's do this. Whoever can do the best belly flop, and we belly flop, we're all gonna just jump in one by one. We're gonna get in line and do this. Come on, sir. Don't lie down don't relax. Come on, have some fun. You're on vacation. This is a fun day. It's a fun cruise. Come on.
So this is a good example of when you're talking with someone, whether it's a client or a family member, and someone is telling you about, their day at a football game or Disneyland or what have you. They may say, "Oh yeah, this person told me A, B, and C," but it's one thing that they're telling you what the person said, and it's another for you to actually see how this person was coming across. So this also helps to tell the story, because you could have your client mimic what he saw, how this cruise ship director was acting with his expressions, with his voice, his inflection, with his hands, to give you a better understanding of what your client observed and why that led your client to make the decision to enter this contest. Do you want to add anything, Scott?
Well, I can give a soliloquy in my role as Nathan, that the more positive reviews I get from the customers, the better I'm going to do. I can potentially get a bonus. I could potentially get a promotion. So I need to make sure all of these people have as much fun as possible, because that's going to help me in my work for this ship. So I've got to make sure I get these people up and moving, because if they're involved in the activities, they're going to have fun, and I'm going to get better reviews, and I can make more money.
And that helps with one of the themes, the corporate responsibility versus assumption of the risk. With there's some type of reward that this employee from the cruise ship who's putting on the event, it's not about safety. And there's some information in the facts also that says that his supervisor specifically told him no more belly flop contests. But the cruise ship director still did that. And part of this version is his motivation or incentive was not about safety. It was about money. He wanted to get the bonus. He wanted to make extra money. So was he really thinking about Nathan's safety and the safety of the other passengers? That's not what the motivation was. So it also helps to get into the mind of the defendant and the different actors who were there and the different individuals who were there. Okay, then, so we want to get to the part about the belly flop, and then obviously because of the injury and the extent of the injuries, and Nathan going on this cruise for fun, a vacation with his wife, he thought he would be safe because they are telling him, come on, we've got your back, we have you, come on and do this contest, it's going to be fun. Well, you think if you do something and you put your safety in someone's hands, there's some type of feeling of betrayal when you are injured. It's like, whoa, they weren't really looking after my safety or my well-being. They were looking just to make money. So we want to explore that also. So why don't we continue in your role as Nathan about what happened during the time of the incident, and then talking about the betrayal that you felt.
So I didn't really want to get up and jump on the pool, but this guy is right in front of me telling me I got to get up and do it. I should do it. It's fun. And I'm sort of a people pleaser, and I just thought that, okay, well, I'll do it. So I got up, and then I waited in line, and I'm standing in line next to, there's roughly 10 people in front of me, and one by one they're jumping in, and I'm not a big swimmer. I don't swim very often, and I don't really know about different dives and things, but everybody was just jumping in. So when I went, and they were going like one by one, and one by one by one. And when they jumped in, they'd go, and the next person would jump in. And then I went, and I just went to jump in, and I just went, and like I normally do to jump in a pool, and went like this. And then I don't remember very much, but I remember the pain. My neck immediately hurt like heck, and I felt foggy and dizzy. And I remember just not knowing which way was up when I, was in the water, and they helped me out of the pool. My wife helped me out, and Nathan helped me out, and everything was dizzy, and I had trouble walking. And they took me to the infirmary or whatever they call it on the ship, and my life has not been the same. And they told me, he told me to join the contest. And I figured, if this is what they do every cruise, and it's part of the package, part of the activities, like, the thought didn't occur to me in a million years to like think about how deep the pool was or read signs. I was just, we were there on vacation to have a good time, and I was just following what he told me to do. I had no idea that the pool was social. I mean, in a million years, I would never jump into a pool if I knew it was dangerous. But this is their, I was doing what he told me to do. It's their ship, their activities. And my life's never been the same.
And pausing here, so in setting up the scene, you saw that Scott, who's playing the role of Nathan, but Scott got up and he's standing up. Have your client do that as well. Use whatever you have. If you're at the client's home and you need to use a chair, you need to use a table, any type of props to set things up so you get the complete visualization of how everything looked. Do that. Have them get up and talk about it. It's one thing for them to say it verbally, but another thing for them to actually show you, where it's going to help you to bring the story together. And then the feelings of betrayal. Again, we know this, many of us, in prepping our clients for a deposition, let alone a trial. It's been very difficult at times to get clients to open up because they have no choice in the matter. They have this pain. They have these injuries that they're living with day in, day out, but they have families, or they need to work to support their families. They need to continue on with their lives. So a lot of times they'll put up barriers. And when you want to really bring out what their life was like before and what their life is like after this incident and how it's dramatically changed, to them, it takes time to get them to open up about it because, again, they're so used to putting this wall up. But you can't overemphasize enough to them that this is your time to tell them how this has changed your life. You're not the same person you were before. And in this case, Nathan's wife, we would be talking to her as well. She's turned into an independent woman that he had fallen in love with. Now they're brand new parents, to a caregiver, not just for their newborn, but for her husband. So this is all a process in bringing out the story. And then, Scott, I want to open it up for you to comment. And then Scott's going to also give you an example of an opening statement regarding these facts as well.
Yeah,
So,
maybe I'll just jump to that since we're limited
Sure.
in time.
Sure.
So this could be a piece, of the opening or a piece of the closing, but it'd be something like this, like if you were there, you would have seen that it's a beautiful day outside the pool on the ship. There's a cool breeze going through the air. The sun is shining. Nathan's lying on a deck chair in his bathing suit, lying down on the white deck chair with the like rubber strips across the deck chair. And he's lying there next to his wife. And there's a row of deck chairs with other people. The person next to him is eating chicken strips and French fries, and that air, you can smell the chicken strips and that fried smell in the air. And there's a pool that's about 30 feet by 20 feet right in front with beautiful blue water. And if you look over the left side, you can see the edge of the ship and the railing and the beautiful ocean behind it. And if you saw Nathan at that time, you'd see Nathan was sitting, lying down in the chair. It's a beautiful day. Got my 7-Up. My wife's next to me. I'm so happy. I feel great. So relaxing. And then what happened next is Nathan, the activities director, walked over, and this is what you'd see. Come on, everybody, it's time for the belly flop contest. Come on, come on. This is part of the cruise. We do this every cruise, and there's going to be a gift certificate for the winner for the bar, and we're going to see which of you can do the best belly flop. Come on, sir, come on. This is a great day. It's a fun day, and you got to join the activities. Come on, don't just sit there and be lazy. Come have fun. We're all going to have fun. Come on, you, sir, come on. Sir, come on, here. Come on, I'll even help you out. Come on, everybody. This is so much fun. It's great. We're going to jump off the right here off the side of the pool, one by one, and we're going to see which one of you can actually make a big splash. And we're not just going to have a gift certificate for the winner, but you're also going to take photographs, and that's part of your cruise. We're going to put a smile on your face. So come on, everybody, come on. That's just a little piece of what could be in an opening statement. And as you do reenactments with your clients and discover actually what happened, there's going to be different things that you would emphasize. But by putting it in a first-person fashion, the jury is actually watching it happen. And it's happening in the present tense. And so the jury is actually seeing it. So it's one method of persuasion that can be incredibly powerful when it's used for the right part of the case.
That has a lasting impact. It's, you could tell someone something, but they may forget. But if you show them and they have certain feelings from seeing it, that's going to leave a lasting impression. And if you could get that across to the jury, that's going to be even more powerful. We know that most of the members of the jury don't want to be there. They're bored. They're twiddling their thumbs. They're looking at our shoes, fingernails, what have you, not really paying attention. Some are bobbing their head, falling asleep, or some even fall asleep. But if you present that story and bring it to life as though you were taking them back to the day when this happened, and they can see for themselves. It's one thing for the cruise ship director to get on the witness stand and testify, and he's going to say his version of the story. It's another to actually get up and show, like Scott did, in terms of taking them back there to what Nathan observed on that day, of how the cruise ship director was acting, how inviting he was, how he was making this appear to be so innocent, no problems whatsoever. Don't worry, everyone's fine here. This is just for fun, meaning no risks involved whatsoever. Why would anyone think there's going to be any type of risk? When you show the jury and bring out the story that way, that tends to leave lasting impressions. So with that, we want to find out if anyone has any questions. If you do, please feel free to put them in the chat. I don't know if the facilitator has seen any questions come up. If not, we can wrap things up. We still have a little bit of time, but we have more content we can cover as well.
We've got a couple questions, and I'll read them. The first one
perfect.
is, what strategies do you use to ensure a client's testimony at trial remains authentic and does not come across as rehearsed after several recitals trial prep?
That's very important. We definitely don't want, you don't want the testimony to the point of being rehearsed. You want it to be authentic. But I'm going to hand this over to Scott because he has a wealth of information on it as well.
Yeah, so that's a great question. And the idea is it's got to be truthful. So the way that I like to do is when you're doing your reenactments, when you're doing it with your client to discover what happened, you're going to go through it and ask, well, what are you seeing? What are you hearing? What do what's your soliloquy? Like, what's your internal voice telling you at this time? And as long as it's true, and as long as it's true and authentic, it's not going to appear rehearsed because it's true. And that's the key, is that when you work with your clients, make sure that you tell them. What I do is before we go back and do a reenactment, I say, okay, I want you to take a minute. I want you to close your eyes. I want you to tune in with back in this moment. I want you to go there, and I want you to visualize, how your body is. I want you to, breathe the way that you were breathing back then. I want you to feel yourself in your body so that they can tune in. And when you're tuned in, then I want you to open your eyes. And then you're asking essentially questions like, what happened next? What are you seeing? What are you feeling? What are you hearing? So there's no direction, in the sense that you're not telling them, well, I want you to say this or I want you to say that. You're just listening. You're just listening and asking questions that you're curious about, so that when you do a reenactment in the courtroom, that it's true because you've seen it, right? You've watched your client do it, and you've gone over it with your client. But if it's true and authentic, which it will be, it's not gonna come across as rehearsed or fake, because it's true. And I'll read the second question, Liz. How would you handle a case of a client who has what may be considered as negatives? My client's an adult movie star. She has severe facial scarring as a result of vehicular injury. There's no loss of earnings, so we need to go into some details about her job. Do you want to start that, Liz, and then I'll jump in after you?
Sure. So thank you for that question too, Mark. So it appears there is a loss of earnings. So that's why he would need to go into details about her job and being an adult movie star. Yes, that's definitely something that has to be explored, especially you're going to want to find out how prospective members of the juries feel about that. However, in this particular situation, that's where discovering the client's story is very important, because what led your client to decide on that profession? Is it something that she felt she was forced into? What are her circumstances, her upbringing? You want to get into that. Maybe she didn't have any support as a child, or there's some things that may have happened in her past that you want to be able to explore. And it may be painful, but you want to be able to explore all of that so you can get the full story. And then from there, once you have all that information, you can then reframe it in a way that it may not appear to be a negative to some people. Was this something that she voluntarily wanted to get into? This was her dream to be an adult movie star? Likely there's a lot more to it that led her into that profession, and part of it has to do with her upbringing. Scott?
Yeah, and I would embrace it. I wouldn't look at this as a negative. I would look at it as something that deal with, I would deal with the first thing in voir dire. Like, hey, look, my client is in the adult entertainment business. This is what she does for a living. So, part of me thinks that people who are in that business, that's not something that I condone. What do you think about it? And you're going to get a bunch of jurors who are going to be like, some of the jurors are going to be like, maybe, yes, I think it's immoral. I think this, which is great. If they tell you that, that. Other jurors are going to be like, that's her job. That's what she does. That's how she makes a living. And if she's injured and can't make money that way, then of course she's entitled to justice just like anybody else would. So I would not run from that at all. And
Right.
Mark, you or anybody else, if you want to contact us afterwards and talk about it further, happy to do that.
Yeah.
Michelle, read the
And
next question. Oh, I'm sorry, Liz, do you want to add?
oh no, I was just going to say that for any of whatever the client's profession is or some circumstances, at first glance you may look at it like a negative, but I'm with Scott. I would embrace that. And there will be members of the jury or prospective members of the jury who they may say, hey, it's not my place to judge. Who am I to judge? So whatever she decides to do for her profession, I'm not going to have an issue with it. If she had to take off time from work, then yeah, we'll consider the evidence before us, whether, she deserves to get paid for that time. So you will hear from people and people will speak up about that, but you will find that there's going to be people who aren't going to hold any judgment, but you also want to explore this whole story of what led her to that profession as well, just so you have the full picture.
Yeah, and let me add to that, things like this is the perfect issue where you see something in a case where you're like, oh my God, how can I win this case, right? My client's an adult, a porn star, right? These are the issues that are the key to big verdicts, because the insurance companies look at something like this and they're like, we're not going to pay any money on a case like this because the jury's going to hate them because they're immoral or whatever. And these kind of things are really enable us as trial lawyers to deal with the truth, the honest truth, and do really great things for our client. I'll tell you, I'm always afraid of stuff like this. Really, I'm always afraid if my client's a meth, uses meth, or you have these things that look like they're such big problems, but in reality they're not, because if you deal with them openly and honestly with the jury, people understand. Just because which of us are perfect, right? Which of us don't have things in our life that we're not ashamed about or embarrassed about? But everybody gets that, and everybody understands that. So and yeah. Well, let me go last. Should I read the last one, Brenda?
Brenda, sure. I'll go
Okay.
ahead and read. It's in cases where a client has suffered severe injuries, there may be situations where they're unable to communicate due to the extent of their condition. In those instances, is someone appointed to speak on their behalf during trial depositions? If so, what does that process typically look like? Do you want to start off with that?
Sure. So, yes. So the way that works is if your clients can't talk, for example, one thing I'd wonder is are they able to communicate at all? Are they able to write? Are they able to, and so normally in court, no one would be sort of appointed to speak on their behalf, but you would have other witnesses that would be able to talk about what their experiences are. In other words, if you have someone who suffered a brain injury, you obviously have hopefully witnesses to the injury itself, or you would have experts to talk about the way the injury occurred and what the impact is. And so that you can have other people talk about what your client is going through, both a recipient witness and expert witnesses to talk about that. But there's also something that we use in psychodrama called surplus reality, where when you want to learn about what their experience is, but they can't talk, you can do some reenactments with putting yourself or an auxiliary, another person, in the role of your client and reenacting what they went through and reenacting what it's like to be in their position now, to be where if you're in a hospital bed, unable to speak, and tuning into what those feelings are, and understanding what the truth is and living like that, that can give you tremendous insight to what your client's going through that can help tremendously in your case. And I know it's a complicated question, and I'm happy to chat with you, offline about it, because there's lots of things, creative things that you can do that can really help you represent your client.
And I know we're probably gonna have to wrap up, but let me just add to that. I had a client who is a minor child, had autism and a severe, meaning a severe traumatic brain injury. Defense counsel wanted to take his deposition. We filed a motion for a protective order. The judge ruled in favor of the defendants. The deposition took place, and it was as clear as, I mean, it was so clear that the extent of our client's injuries, the deposition barely, it didn't even go an hour. Defense counsel kept asking our client questions. He wasn't focused. He wasn't able to verbally communicate that well, but he was able to say no more during the deposition. But you could clearly tell, and it was probably maybe like half hour, 40 minutes, and they stopped the deposition, and that was it. But just in that, if you have your client and they want to take your client's deposition and it does go forward, then defense counsel will likely get the realistic picture that how severe the brain injury is, because just by the inability to verbally talk or the expressions, that came across so crystal clear. And shortly after that, we ended up settling the case. So I know we've gone over about 5 minutes. I want to thank you, and I'll turn it over to Scott to thank you for spending this hour, a little over an hour with us. We're both available if you want to reach out to us, and we thank you for your time. Scott?
Yeah, no, I just want to say it's wonderful. The fact that you're taking time to better your skills, to learn, to help your clients. Fantastic. That's congratulations to you for doing that, because you will get better, and we're all getting better. We're all learning and growing constantly. I know there was a question someone, I think, had asked for our emails, and I'm not sure if that was put up on the chat, but my email is sglovsky@scottglovskylaw.com. That's SGLOV as in Victor, SKY, at Scott, SCOTT, Glovsky, GLOVSKY, law, LAW.com. And Liz?
Mine's listed on the written materials at the very end, the last page, but it's EAH, my initials for Elizabeth Ann Hernandez, EAH at BDJ.com. B as in boy, D as in Daniel, J as in John.com. Thank you all again. We appreciate it.
Thank you. Have a great day, everybody.